Distinguished guests, Assalamu alaikum. Let me just begin by a quote, because I firstly draw inspiration in this entire ADR world of ours from this saying of the Holy Prophet, peace be upon him, who told us that achieving reconciliation between people is better than observing voluntary fasts, offering voluntary prayers, and offering voluntary charity. So it's a big thing to reconciliate and settle matters between us. So that's the kind of driving force behind all this. Let me clarify, because the law minister said that the law is passed through my eyes and I've seen this and this should be the best law there is. And no, let me just clarify that I stand here as a member of the Law and Justice Commission, not as a judge of the Supreme Court. I wear a different hat when we look at this law. I don't wear the hat of a judge of the Supreme Court, so if the law comes before us, if challenged, will be examined differently. So let me clear that, because this is not being presented to the government by the Supreme Court of Pakistan. This is by the Law and Justice Commission of Pakistan, which is a statutory body established under the Law and Justice Commission of Pakistan Ordinance 1979, and its preamble talks about a systematic development and reform of the laws, which is a mandate. And Section 6 of this law in particular provides that they can make laws in accord with the changing needs of society, and we can give recommendations to the government regarding law reforms. And it is in that vein that this effort has been done. The committee was constituted, which we call the Arbitration Law Review Committee, somewhere in April 2023, and I must compliment and acknowledge that the former Chief Justice, Justice Omar Ata Bandial, was very kind in constituting this body. Had he not done that, we would not have been here today. So I must thank him for this, that he accepted this. We made a request and he acceded to it, and he set up this committee. And I also thank the current Chief Justice, Justice Qazi Faiz Isa, for allowing it to continue, and he gave it the blessing that we must complete this work that we'd started. So the need actually, let me just underline what was the real need for this, and why did we think of revisiting Arbitration Act 1940. For us, it's the domestic arbitration as well as the international arbitration. Both are important. There is no doubt that the underlying feature is the businesses and the commerce behind it, but it applies to both the domestic as well as the international arbitration. So the pendency in our country, which I've mentioned several times in various forums, we have 2.4 million cases, and they're not really moving. They're there. And we're talking about 5 high courts, we're talking about district judiciary, we're talking about ex-cadre courts, a total of about 2.4 million cases that are not really moving. So the pendency, largely about 85% of it is in the district courts. And we think that by setting up, which I'll speak later, about ADR centers and the new arbitration law would ease things in domestic arbitration, amazingly. So the way things will change with this new law in domestic arbitration would actually be addressing this backlog and this pendency, which needs to be addressed. It's been high time that we do that now. We must also acknowledge that and understand that about 70,000 cases are being filed every day in the district judiciary in Pakistan. 70,000 cases are being filed every day, and about 4,000 cases are being filed per month. 70,000 cases are being filed per month in the district judiciary, and 4,000 cases per month are being added to the high courts. So we need to understand what's the need for having alternate avenues available to us in the shape of arbitration or mediation. Let me also flag that 1.6 million cases were decided last year in the year 2023. Still, the pendency remains at 2.4 million. So you can just imagine that there's a lot of work coming to courts. A lot of people are approaching courts, a very litigious society. Number of cases are coming in. We need to find avenues to address this, because we are in the business of dispute settlement. So this dispute settlement mechanism needs to have avenues. We've just started work on the arbitration, as you see, on mediation, on ADR centers, and at the same time we're trying to work on technology to address matters which are going to be addressed by courts, and trying to bring in AI and information technology going down to courts to figure out how district judiciary ought to refashion itself and to address these challenges. So the you've already heard from, so I just want to really sort of take you through the process, which is very important. What did we do when the committee was constituted? How did we go about it? Because the transparency of the process is important. So the committee, we sat down, we met in April last year, and I must thank Barrister Makhdoom Ali Khan, who was the lead in this committee. Then we have Mr. Faisal Naqvi, Mr. Samiuddin, and Faisal Kokar, one of our ablest senior civil judges that we have at the Supreme Court Research Center, was part of this process. So a number of deliberations took place, number of meetings took place, and it was in our discussions that we decided to carry this forward and put out a public draft eventually, which went out on the website, and it was open to the public to comment. But more importantly, Mr. Faisal Naqvi, who was the force behind it, actually after the first meeting came up with the first draft in a couple of months, and I think that deserves a big clap, because on 17th of August he came up with the first draft, which we thought was amazing, because he took the charge and he said, I'll do it. And he came up with that with the assistance of Samiuddin and under the supervision of Barrister Makhdoom Ali Khan, which was amazing. And I think the real work has been done by them. I'm just a ceremonial head here of this committee. The real exercise has been done by Faisal Naqvi and Mia Samiuddin with the assistance of Zafar Kokar and under the supervision of Barrister Makhdoom Ali Khan. So I think a big compliment goes to them for doing this exercise in this limited time frame that they had. So once we sat over several meetings, that the draft came before us, we looked at it, we deliberated, and there was a second draft, and then the draft was put out, as I said, out to the public on the website for people to comment. And then also the matter was, the draft was shared with a lot of prominent law firms, the High Court Bar Councils, Chambers of Industry, domestic arbitral institutions, and international arbitral institutions like LCIA, ICC, and the Permanent Court of Arbitration. In total, the draft was sent to about 100 stakeholders to review and look at it, you see. Online discussions were held by Mr. Faisal Naqvi with various international institutions and centers in relation to issues of international institutional arbitration. So it was ICC, it was Delhi International Arbitration Center, it was the Permanent Court of Arbitration, it was the Dubai International Arbitration Center, the Saudi Center for Commercial Arbitration, International Arbitration and Mediation Center Hyderabad, BVV International Arbitration Center, Asian International Arbitration Center, International Advisory and Dispute Resolution Unit, Hong Kong International Arbitration Center, Korean Commercial Arbitration Board, in London, the Court of International Arbitration, and all these discussions were made possible by David Grief and Toby Landau, who you just heard. The ALRC is grateful for their assistance. So this draft went around all over the world, and people looked at it and made their comments. So one would not be wrong in saying that perhaps it is one of the most, state-of-the-art laws coming out on arbitration in the world. And I think it deserves a big clap, you see, the team. So, having said that, what is important now is how do we go forward, you see. We've seen the salient features, we've talked about it, Mr. Faisal Naqvi talked about it, Mr. Makhdoom talked about it. I just sum it up in 4 points which I think are important. It's the reduction of judicial intervention in arbitral proceedings. That's one main big thing. Because earlier, in the first round, under 1940, you would go doing arbitration, and then you'll probably end up the rest of your life in the courts dealing with that arbitration. So nobody really went for arbitration because it was like doubling the exercise. You go for arbitration and you end up in court. So the reduction of judicial intervention, I think, is the big salient paradigm shift. The speedy resolution of disputes, timelines for different stages of arbitral proceedings is again a welcome addition to this. Then the recognition of the principle of party autonomy is brought in and caters for institutional arbitration. Now on the issue of institutional arbitration, I'll be requesting the Law Minister here to please consider that we go ahead and set up the first International Commercial Arbitration Center in Pakistan. This is much needed and it's been waiting for such a long time. I've been informed by the former Attorney General that about $7 million was spent as costs in taking matters out to London or to other places for arbitration because we didn't have a facility of our own. So it's high time that we set up that center in Pakistan, and that would energize the entire sector. A lot of private sector players will come in to set up their own centers, and good, let them do that. These are the avenues that we need to develop. People need to get out of the courts and go out to these forums. I'm not talking about mediation today, but that's another aspect. So it's mediation, it's arbitration. We need to open up these doors because we can't just bring in every case to court and think that we'll decide every matter. We cannot decide 2.4 million cases. We need to take them out to mediation, take them out to arbitration. And with this new law, I'm very positive that things will totally change. So what we're looking in the future is towards a multi-door courthouse, and litigation is the last door to tap on. So people need to understand, and the mindset needs to change, कि हर चीज अदालत में नहीं लेके चली जाना, हमने पहले और चीजें भी करनी है, हमने मीडिएशन भी करनी है, हमने आर्बिट्रेशन भी करनी है, और अगर वो फेल हो जाए तो फिर अदालत का दरवाजा खटखटाना है. यहाँ तो आप सारा दिन रात अदालत का ही दरवाजा खटखटाते रहते, ये नहीं होगा. Things will have to change. So the future, as I see it, and as we are thinking about it at the court also, is to have ADR centers across 138 districts in Pakistan. When I say ADR centers which will have mediation facilities, then escalating on to domestic arbitration facilities also. And as you see, ADR laws आ चुके हैं पाकिस्तान में, उसमें अभी 1940 लॉ का जिक्र आता है आर्बिट्रेशन का. जब ये चेंज हो जाएगा तो वो एक नई एनर्जी उन ADR के लॉज में भी आ जाएगी, बिकॉज कोर्ट इंटरवेंशन पॉसिबल नहीं होगा. तो वो एक चीज हमें आगे की तरफ चलना है. ये कोर्ट एनेक्स टू मीडिएशन लीडिंग टू आर्बिट्रेशन, ये मैं डोमेस्टिक सीन की बात कर रहा हूं, ये जरूरी होगा. दूसरी चीज जो बहुत जरूरी आगे चलने के लिए है वो ये होगा, और सारी दुनिया में है. In the entire world, we were in Doha and we saw 50 jurisdictions talk to us, and nobody was saying that the criminal cases are important, or service laws are important, or family laws are important. Everywhere in the world, the top preference given to is commercial cases, because connected with the commercial cases is your economy, and connected with the economy is the well-being of the country itself and the progress of the country. So इसको समझें कि commercial courts को आपको बनाना पड़ेगा. हर करीबी जो हमारे साउथ एशिया की भी और बाहर भी कमर्शियल कोर्ट्स बन चुके हुए हैं, हम पीछे रह गए हैं इन मामले में. पंजाब में कुछ बने, लेकिन हमें कंट्री वाइड कमर्शियल कोर्ट्स को लाना है. तो कमर्शियल कोर्ट्स की जब हम बात करते हैं तो उसके अंदर इनबिल्ट है एडीआर सिस्टम भी. So the hybrid commercial court that we're thinking of is a commercial court that talks about commercial arbitration within it, also commercial mediation within it, leading to, if there is a dispute that escalates into a court, is a commercial court. अब ये कमर्शियल कोर्ट खाली नहीं चलेगा और खाली आर्बिट्रेशन भी नहीं चल सकेगी अगर हम स्पीड नहीं लाएंगे अदालतों में. देखिए कुछ मैटर्स तो अभी जिस तरह उन्होंने फैसल साहब ने भी कहा, अवार्ड्स को चैलेंज भी हो सकते हैं कुछ, और कुछ वैसे भी लोग चैलेंज करेंगे, राइटली और रॉन्गली, but they'll come to court. So sooner or later somebody will be knocking the doors. Even though we have the state-of-the-art arbitration law, people will still knock the courts and say, knock the door of the courts and say that we are here. देखें चाहे फ्रिवलसी केस हो, आएंगे जरूर. इसी तरह हमें ये अब देखना है कि अगर हम नीचे अगर फैसला कर भी दें ट्रायल कोर्ट के लेवल पे, डिस्ट्रिक्ट कोर्ट के लेवल पे, तो हाई कोर्ट पे आके अगर उसने 10 साल रुकना है, मखदूम साहब ने टाइसी का केस का जिक्र किया, 11 साल या 12 साल सुप्रीम कोर्ट में पड़ा रहा, तो फिर ये नीचे सारी चीजें करने का तो कोई फायदा नहीं. इस नए आर्बिट्रेशन लॉ बनाने का भी कोई फायदा नहीं अगर सारी चीजें रुक जानी है अदालतों में आके दोबारा. तो इसलिए अगर इस आर्बिट्रेशन लॉ को या मीडिएशन की जो हम बातें करते हैं, मीडिएशन तो चले सेटल हो गया, आर्बिट्रेशन के कॉन्टेक्स्ट में अगर आगे चीजें आनी है तो यू नीड टू हैव अ फास्ट ट्रैक कोर्ट, जिसके लिए जिक्र पहले भी हुआ, कमर्शियल कॉरिडोर अगर नहीं हम बना सकते पाकिस्तान में तो फिर ये सारी चीजें नहीं चलेंगी. क्योंकि डिस्ट्रिक्ट जज अगर अवार्ड पे फैसला भी कर देगा तो आके हाई कोर्ट में अगले 5-10 साल के लिए रुक जाएगा और फिर 10 साल के लिए सुप्रीम कोर्ट में रुक जाएगा, तो सारा कानून बनाने का तो कोई फायदा नहीं हुआ. इसलिए I think the future vision is, and we're thinking on these lines, and I think the government needs to consider that also, there has to be a commercial corridor so that we have a commercial court, we have a commercial division at the High Court which has a time frame working. उसमें family case और land और preemption के केस नहीं चलेंगे, उसमें सिर्फ commercial court के केस, commercial matters चलेंगे. इसी तरह at the Supreme Court we need to think of having a commercial division which will cater to this. And considering the state of our economy, as pointed out also, I think it is high time that we start put this focus on attending to commercial matters very seriously. अब उसमें टैक्स भी आता है, उसमें बैंकिंग भी आता है, उसमें बिजनेसेस की अपनी प्राइवेट ट्रांजैक्शंस भी आती हैं. ये सारी चीजें अलहदा करनी पड़ेंगी और फास्ट ट्रैक पे चलाना पड़ेगा. So basically what I am trying to say is that the arbitration law alone will not work unless and until we have a speedier court system that sort of blends with it. Otherwise ये अकेला नहीं कर सकेगा काम अपना. और कोशिश ये है कि कमर्शियल कॉरिडोर डेवलप हो और इन चीजों को हम आगे ले जाएं, कमर्शियल कोर्ट्स बनाएं, ADR सेंटर्स बनाएं और लोगों को ये बताएं कि देखें सिर्फ अदालत आना नहीं है, ये और भी दरवाजे हैं जो आपको जिसको रजू कर सकते हैं आप. जिसके लिए हमारे लिए बहुत जरूरी होगा, ये पहले भी बात हुई है, ट्रेनिंग का. तो ये मैं आपको बताऊं कि बड़ा खुशाइन बात ये है कि FGA ऑलरेडी रन्स these programs here and they are already training judges who come in for training on mediation and on arbitration, and now they will train them under this new law. We at the Supreme Court, we at the High Court level also have to understand this new law. There will be new jurisprudence that will be fashioned, which is fine, which will take time and will evolve. लेकिन अगर जल्दी हो, अगर 10-20 साल लग गए इसकी evolution में, तो फिर प्रॉब्लम उधर का उधर ही रह जाएगा. इसलिए maybe the commercial division of the high courts will work. And the legal community has to also understand, and I request the lawyers sitting here also, and I keep hammering that point कि हमारी जो अदालतें स्लो चल रही हैं, कुछ हमारे भी मसाइल होंगे, कुछ रश भी है, कुछ काम भी ज्यादा है, पर कुछ आप लोग भी हैं. 80% एडजर्नमेंट्स के ही वजह से लेट हो जाता है काम. तो इसलिए इस चीज को भी देखें, स्ट्राइक्स के बारे में भी ख्याल करें जरा. अगर ये सारा हम निजाम चेंज करने लगे हैं और तेजी लाना चाहते हैं चीजों में, तो फिर आपका रोल भी बीच में आएगा. और मेरे फ्रेंकली मैं आपसे शेयर कर रहा हूं ये बात कि वर्ल्ड बैंक की रिपोर्ट के मुताबिक 80% तो एडजर्नमेंट की वजह से डिलेज हैं. तो वो उसको देख लें कि ये आगे नहीं चल सकेगा सिलसिला डिलेज का, आपको इनको चेंज करना पड़ेगा. और दूसरी बात ये होगी कि जो स्ट्राइक्स का कल्चर आपने एक बनाया हुआ है, दोपहर को कर लीजिएगा, शाम को कर ले किसी वक्त जाके, अदालत के टाइम में तो गुजारिश ना करें, वरना ये सारी चीजें फेल हो जाए. आपने टीवी के सामने जाना है, शाम को चले जाए, हर वक्त होते हैं, चैनल्स चलते हैं, आप कर सकते हैं. यू डोंट हैव टू डू इट ड्यूरिंग द कोर्ट आवर्स. सो इसके अलावा जो एक और चीज आपके साथ शेयर करना चाह रहे हैं कि अदर देन ये एवेन्यूज जो हम बना रहे हैं, मीडिएशन, आर्बिट्रेशन के अलावा जो कोर्ट में केसेस कुछ ऐसे होंगे जो कोर्ट में ही चलेंगे, उनका कोई तरीका और नहीं हो सकता. उसके लिए हम टेक्नोलॉजी लाने की कोशिश कर रहे हैं, एंड वी टेकिंग द टेक्नोलॉजी डाउन टू द सिविल कोर्ट, डूइंग अ लॉट ऑफ थिंग्स कि अगर हम उसको इम्प्रूव कर सकें, डैशबोर्ड्स वगैरह वगैरह. उसका आज दिन नहीं है बात करने का, लेकिन टेक्नोलॉजी का सहारा लेना पड़ेगा. हम वो कॉलोनियल स्टाइल पे और रजिस्टर्स उन पे नहीं चल सकते. काफी काम हुआ है लाहौर में भी, जैसे सुजात भी यहाँ बैठे, उन्होंने भी चीजें की हैं. इस तरह की चीजें हमने आगे लानी है और करनी है. So end पे I once again you see I want to thank, and I think I've missed out 2 other members of the committee who are from the government. एक कशुर रहमान साहब बैठे हुए हैं, एक अम्बरीन थी अब्बासी हमारे साथ, उनका भी बहुत शुक्रिया. Once again I want to thank the committee and the members of the committee who did the real work.